are a batch of the PILs challenging the validity of the certain provisions of the 1991 law that prohibits the filing of a lawsuit to reclaim a place of worship and seek a change in its character from what prevailed on August 15, 1947. A three-judge bench of Chief Justices Sanjiv, Khanna and Justices Sanjay, Kumar as well as KV Viswanathan will be hearing this matter. The Act preserves the character and identity of religious sites as they stood on the 15th of August 1947. However, there are many petitions that have challenged this Places of Worship Act 1991 that are pending in the top court. The petitions claim that the Act bans the remedy of the judicial review and also violates the principle of secularism. Now, IUML has filed an intervention application in this regard before the Supreme Court in the plea challenging the validity of the Places of Worship Act. So let's get you the details in this case. The Supreme Court, is going to be hearing it in the pleas that challenge the validity of the Places of Worship Act 1991. And this application also states that the 1991 Act seeks to protect secularism and religious freedom of all faiths within the country. So let's take a look at some of the arguments that have been made. Remember, this application also mentions that secularism has been held to be a part of the basic structure of the Constitution. Even Parliament is prohibited from amending this Act. So the Places of Worship Act is going to come up. Remember, that is the bedrock of the arguments that are going on in several disputes across the country. So the argument being that the Act takes away the right of the Hindus, Jains, Buddhists and Sikhs. Let's go across to legal editor Harish Nair, who's joining us on the broadcast to really explain to us the arguments on both sides and what's expected. Harish, what is expected today in the Supreme Court? Take us through the arguments on both sides.
Yes, good morning, Pratibha. Yes, in fact, this first petition was filed in 2020 by the lead petitioner, Ashwini Upadhyay. And after a gap of 1 year, once again, a very crucial hearing, the Supreme Court will be hearing around 10 petitions which have challenged the constitutional validity of the Places of Worship Act, which provides for and orders for a status quo regarding the character of a religious place as on 15th August 1947. Prominent among the petitioners are, of course, the lead petitioner Ashwini Upadhyay, who will talk to us in very short time. He's with me. Then again there is Vishnu Shankar Jain, who will represent the Purohit Mahasabha. Then Subramaniam Swami, Swami Jitendranand Saraswati. Several of them, they have argued that this particular act takes away the right of Hindus to reclaim their places of worship, and also even Parliament cannot deny them. This is in a way legalizing the illegal act of the invaders. At the same time, Muslim sites like the Gyanvapi Mosque Committee and All India Muslim Personnel Law Board had raised the spectre of Sambhal-like incidences and also threatened of very drastic consequences if the Places of Worship Act is scrapped. So today, in fact, and there's another point, Pratibha, that the centre has not even responded to the petition even 3 years and 8 months after the first notice was issued. So all eyes on the Supreme Court hearing. I have with me the lead petitioner in this matter, Ashwini Upadhyay, who will talk about as regards what is expected. Ashwini ji, क्या उम्मीद है?
मुझे लगता है कि आज ये शायद पांच जजों की बेंच को रेफर हो जाएगा, क्योंकि अयोध्या जो जजमेंट था उसमें थोड़ा बहुत इसका रेफरेंस आया है। हालांकि वो ओबिटर डिक्टा है, वहां प्लेस ऑफ वर्शिप एक्ट की मेरिट पे कोई डिस्कशन नहीं था, लेकिन जानबूझ के उस समय मुस्लिम साइड ने प्लेस ऑफ वर्शिप एक्ट के ऊपर वहां बात किया था और वो कुछ पैरा में नोट हो गया है। तो शायद ये मामला 5 जजों के रेफर हो जाएगा, लेकिन ये मामला हिंदू मुस्लिम का नहीं है। ये मामला पूरी तरीके
आपका मेन आर्ग्यूमेंट क्या है?
हमारा मेन आर्ग्यूमेंट है कि आप कोर्ट का दरवाजा नहीं बंद कर सकते हैं। आप लोगों को अगर कोर्ट जाने से रोक देंगे तो भारत में डेमोक्रेसी खत्म हो जाएगी, यहाँ भीड़ तंत्र हावी हो जाएगा, लोग अपने फिर धार्मिक स्थानों के लिए फिर डंडा लेके सड़क पर उतर जाएंगे। वो बिल्कुल ठीक नहीं है। हमारा ये भी कहना है कि इस कानून का नाम प्लेस ऑफ वर्शिप एक्ट है और प्लेस ऑफ वर्शिप जो है उसको कहते हैं मंदिर को, मस्जिद को प्लेस ऑफ प्रेयर कहते हैं। पहला तो दूसरा, ये कानून ये कैरेक्टर की बात करता है, आइडेंटिटी की बात नहीं। मैं एग्जांपल देता हूं, मैं अभी सुप्रीम कोर्ट में खड़ा हूं, काली कोर्ट में, तो मैं वकील दिख रहा हूं। मैं हॉस्पिटल में जाके सफेद कोट पहन लूं तो मैं डॉक्टर दिखूंगा। मैं थाने में जाके अगर खाकी पहन लूं तो मैं इंस्पेक्टर दिखूंगा। ये मेरी आइडेंटिटी है। मेरा
कुछ इंटरव्यूनर्स लाइक ऑल इंडिया मुस्लिम पर्सनल लॉ बोर्ड और ज्ञानवापी मॉस्क कमेटी ने ऐसा बोला कि प्लेस ऑफ वर्शिप एक्ट स्क्रैप करने से संभल लाइक इंसिडेंसेस हो जाएंगे, इट विल क्रिएट अ फियर इन द माइंड ऑफ द मुस्लिम्स।
नहीं, जो लोग ऐसी बात कर रहे हैं वो भारत के संविधान की धज्जियां उड़ा रहे हैं, संविधान की इंसल्ट कर रहे हैं, सुप्रीम कोर्ट की इंसल्ट कर रहे हैं। ये तो खुलेआम धमकी देना हो गया कि अगर आप कोर्ट में मुकदमा चलाओगे तो हम पत्थरबाजी करेंगे। मुझे लगता है ऐसी बातें जो लोग कर रहे हैं उनकी पिटीशन भी डिसमिस होनी चाहिए और पत्थरबाजों के खिलाफ कठोर कार्रवाई भी होनी चाहिए। बहुत सीधी सी बात है ये।
लेकिन मैं बोल रहा हूँ ये सेंटर जो है, इनफैक्ट बीजेपी हैज बीन डिफेंडिंग द प्रोसीडिंग्स एंड ऑर्डर्स इशूड बाय सेवरल कोर्ट्स रिगार्डिंग सर्वे, ज्ञानवापी, बोधशाला एंड ऑल्सो दिस Mathura hearings, but the BJP government has not filed an affidavit even 3 years and 9 months after the first notice was issued. Why the government is not making it clear? And also Prakash Karat, CPM, has said the government had majority since 2014, and why the act was not scrapped through parliament?
देखिए, पार्लियामेंट में क्यों किया नहीं किया मेरे को नहीं पता, लेकिन एक जुडिशियल डॉक्ट्रिन होती है, उसको कहते हैं साइलेंस इज एक्सेप्टेंस, हिंदी में कहते हैं मौनम स्वीकार लक्षणम। अगर केंद्र सरकार ने 4 साल हो गए हैं अभी तक प्लेस ऑफ वर्शिप एक्ट की हमारी पीआईएल पे काउंटर फाइल नहीं किया है, तो ये माना जाएगा साइलेंस इज एक्सेप्टेंस, यानी सेंट्रल गवर्नमेंट हमारी पीआईएल का समर्थन कर रहा है। अगर विरोध करना होता तो अब तक फाइल कर चुके होते। 4 साल बीत गया है, टाइम बार हो चुका है, उनको टाइम मिला, 4 बार टाइम मिला और अभी तक फाइल नहीं किया, देन देयर इज अ डॉक्ट्रिन साइलेंस इज एक्सेप्टेंस, यानी केंद्र सरकार हमारी पीआईएल का समर्थन कर रहा है।
So this was the lead petitioner in this case, Ashwini Upadhyay. In fact, talking about what is expected today, he says that most likely, since constitutional issues are involved, and also a 5-judge bench of the Ayodhya judgment had spoken about, taken a stand about the Places of Worship Act, saying that it is an act to protect the secular fabrics of the country, and the historical wrongs cannot be remedied by people by taking law into their hands. So he expects that since that was a 5-judge bench, this matter may be referred to a larger 5-judge bench. So we'll have to wait and watch what happens. The 3:30 is when the matter comes up for hearing. Pratibha,
Okay.
back to you.
Okay, all right. So while he argues that the act takes away the right to really reclaim properties, you made a mention of the IUML filing an intervention plea as well. Harish, request you to stay with us. Let's play out for our viewers what the IUML has said in its petition, which Ashwini Upadhyay said was fear-mongering. So, in its petition, the IUML goes on to say that it can prevent Sambal-like incidents. So, speaking about the violence that broke out in Sambal, it goes on to say that the Places of Worship Act could prevent a Sambal-like situation, a Sambal-like incident yet again, saying the act seeks to protect secularism in the country and religious freedom as well. So this is the argument that has been made in the intervention plea by the IUML, saying that there is secularism that's mentioned in the constitution and it protects that secularism. Secularism will be held a part of the basic structure of the constitution, saying, that is the reason why it cannot be challenged, because it threatens secularism in the country. The IUML in the top court has gone on to say that even the parliament is prohibited from amending this act. So that's the